You're listening to The Money Hour with your host, Tina Mitchell, and co-host Keelan Harvey on Alternative Talk AM 1150. Now, back to the show with local mortgage experts Tina Mitchell and Keelan Harvey.
Welcome back to the Money Hour with your host, Tina Mitchell. It's the Saturday, April 20th show.
And your co-host, Keelan Harvey.
Your local mortgage experts. We are here to help you build a strong financial blueprint 1 week and one show at a time. If you're hearing our show at a different time or day, you are listening to a rebroadcast, but we're here to connect you with the guest. Please call the show at 1-855-400-1150 or online at themoneyhour.com. Again, that's 1-855-400-1150 or online at themoneyhour.com. In studio right now, first time for our guest, we have Brooke Quist of Seed Intellectual Property Law Group, Strategic Advantages and Pitfalls in Patents. Ignorance is not bliss. Brooke, thank you so much for joining us today. So excited to have a conversation with you.
Thanks for having me. It's a pleasure to be here.
And a little bit about Brooke. Brooke is a partner at Seed Intellectual Property Law Firm, LLP, with over 22 years of experience in intellectual property law. Prior to joining Seed IP, Brooke was a partner at Steptoe Johnson, LLP. Before practicing law, Mr. Quist was a senior research and design engineer in the aircraft division of Northrop Corporation. Brooke specializes in domestic and foreign intellectual property, including strategic portfolio development, patent preparation, and prosecution. Freedom to operate opinions, patent invalidity and non-infringement opinions, due diligence investigations, client counseling, licensing, and technology transfer agreements. Brooke lectures on U.S. patent practices at the University of Washington's renowned Center for Advanced Study and Research on Innovation. And I know, Brooke, that you actually just earlier this week, you did a really big speaking engagement. How'd that go?
It went well. I've been speaking quite a bit recently. I spoke at the WISPLA event, which is a Washington State Intellectual Property Association, and then also yesterday was at the Washington State Bar Association for our 24th annual IP Institute. We had lots of great speakers there, including the director of the U.S. Patent and Trademark Office came and gave a great speech as well.
That is awesome. Yeah. I know you do a lot of educating around patent, and that's why we have you here in studio. So excited to have you.
Super. Happy to be here.
Brooke, that's really cool. I'm a big fan of Shark Tank, and that's my exposure to patents where they talk about that all the time. You got a patent, is a utility patent. And I was like, wow, that's kind of important if you think about it. Why should you, for our listeners out there, care about your patent?
Yeah, it's interesting you bring up Shark Tank because that's most people's exposure to patent laws.
Yeah, right.
And so it's a good takeoff from there is, why do they always ask, do you have any patents? And the reason is they want to know, do you have a competitive advantage in the marketplace? Mm-hmm. Is there anything that's going to be a barrier to your potential competitors coming in and trying to do the same thing you're doing? Because there's always going to be someone who's bigger or, can do things cheaper because, of where they're located or so forth. And so if you have some way to protect what you're doing, that's going to give you an advantage, and it's going to make someone like those in Shark Tank who are investors know that it's a good investment. When I was speaking yesterday at the Washington State Bar Association, I was moderating one panel, and we had an investment banker there, and they said that of every single company that they currently had on their portfolio, they all had an IP strategy. They all either had their own patents or were licensing patents or had some way that they were protecting what they're doing. Now, that's not always going to be true. These guys were particularly focused, but it just really shows that that's going to give you an advantage. And that's not the only way it can be done. You can also, some companies will license, they're not actually doing what the patents do, but they're licensing their patents out to others. And that can be a way that someone small can compete in a big space. I had one client who was a stay-at-home mom, and she had an invention that was a pet-related device, and she was never going to be able to compete with all the big dogs in that market, no pun intended. But we were able to get a license agreement with her for one of the big companies, and then she could have that money kind of roll on in from that investment. And also, that's a way that someone small can keep from being protected against someone big, is if you license to one of the big guys, then they can fight off the other big guy instead of you having to do that.
Yeah, and we hear about that on Shark Tank too, the licensing.
Kevin O'Leary, what's going to stop me from taking your idea and squashing you like a bug?
Yeah.
He's got endless. He's Daddy Warbucks. He's got endless pockets. So.
Yeah, those are valid questions. You want to make sure you ask those.
Yeah.
So, Brooke, what are some other real benefits of having patents?
So one thing that they sometimes don't get into it in as much detail in Shark Tank, but if you were following up on their after conversations, you probably would, was not just do you have patents, but are your patents really on what your technology is or whatever it is that you're selling? What's your business model? Where are you making your money? And is that where your patents are located? Are they really strategic right on your business development strategy? Because lots of people will file patents with the best of intentions, and then the direction of the company tilts a little bit. They go in a different direction, and they wind up with a bunch of patents that really aren't that valuable because they're not on what they're really doing. So, for example, I had one client that recently went through an acquisition from a multi-billion-dollar company, and as we were going through the due diligence, one of the things that the company that was acquiring them wanted to know was, match up your patents with your product. Show me where the patents and where these claims match up with what you're actually doing, with what you're selling, with how it. And if you have that, that's great. That's powerful. If you don't have that, then it's nice, and those patents can give some good feelings, some goodwill, some confidence to your engineers or other technical people, and that might be great, but it's not near as powerful as if they're really protecting your product. Another thing to look at. Sorry to keep going here, but another thing to look at is, are you really at a choke point in the marketplace? Are you, with what you're protecting with your patent, is that the only way to do something? Because if it is, that's going to be a lot more powerful. If you are doing something and you get a patent on it, let's say a way to encrypt a file, there's 20 different ways to do that, maybe even more. So just because you've protected your way that you're doing it, your competitors can do something that's equivalent, that's different than what you're doing, but achieves the same effect. So that patent isn't going to be near as powerful. But if you've got the only way that something can be done, that's something that's really going to give you a big advantage.
So, Brooke, would you say kind of like an estate plan and your financial plan and your taxes? I mean, you're looking at these things on an annual basis. Is that important when you have a patent as well, that you're having it reviewed by your attorney to make sure that any changes that are happening, that you're kind of, looking at that, or is that not necessary?
Yeah, so it's a little bit different than that, but let's start out and explain that the patent prosecution, the process during which you get the patent, is a several-year period. So the patent office likes to say on average it's 3 years. So let's just go with that for sake of argument. And it may be, I think they like to estimate 14 months before you get your first official review of that patent.
Okay.
And then usually that first official review, they tell you that you can't have the patent for one or more reasons. And actually that you kind of want to get that. If you get a first action allowance, it's kind of like if you get a new job and you ask for a salary and they go, yes, right away. You're like, I didn't ask for enough, did I?
Yes.
So usually, not always, but usually you're trying to ask for enough that the first thing you get is a refusal, and then you go back and you explain to them why you're different than what's out there and why you should get that patent, and then you go through that back and forth process. During that year or 2 or 3, you should be in contact, your patent attorney and the client, the company or the engineers or whoever is taking charge of that reign, should be in contact and letting your patent attorney know how your product has developed in that period of time.
Okay, yeah, of course.
So that when you have those opportunities to amend your claim section as you go through the patent prosecution process, that you can keep it on focus. Or you might find that if unfortunately that product didn't make it. The company went another direction, and then so you may not want to pursue that. Or you may want to get the patent and see if there's an opportunity to license it or sell it to someone else. But by keeping abreast of what's happening during that course, you can make sure that you keep it on focus.
Yeah.
Another thing to account for is maybe your product that you're making in-house is different or stopped, but your competitor is doing something. So you want to make sure that you try and get something that's going to cover your competitors, assuming that you've got support for that in your patent, so that you've got an advantage in the marketplace.
Got it.
That's really interesting. I noticed on Shark Tank, you have somebody that comes in with a product, and then they'll mention their patent, and then all of a sudden the sharks light up like, oh, wait a second, because it's all about how your patent is written and designed. And some of these business owners that are pitching it have no idea on how valuable just their patent is. Their product is worthless, but this patent and the way it's verbalized, is priceless. So they get all excited about that and show a completely different angle. In your opinion, Brooke, what makes a patent more valuable than the next?
Well, like we were saying there, partially it's about does your patent cover actual technology that's either you're using or other people want to use? So if you have a patent and it's on technology that's either not being utilized by you or by someone else, that's going to be less valuable. The easiest way to put a valuation, to put a price on something, is if there's an actual marketplace for it. So if you can say, oh, I'm selling these products and I can attribute these sales directly to my patent because I'm selling and my competitor's not, and the reason I'm selling is because I've got a patented feature. That's the easiest way to do it.
Makes sense.
But there's other times when someone like the sharks you talk about, or the investment banker I had on the panel yesterday, will say, oh, that person has patents and they don't realize how valuable they are. So they will sometimes, when that company goes under or needs financial, is in financial distress, they'll have an opportunity to buy those up and then apply them to an area that they know has potential value.
Wow, that's sneaky.
That's really sneaky. So, Brooke, what about dangers, the biggest danger when it comes to patent law?
Yeah, so the biggest dangers that a lot of small businesses and independent inventors don't know is that you can actually bar yourself from getting a patent if you don't act quick enough. Now, with other types of intellectual property like trademarks and copyrights, you can have your copyrighted material, like your website or your book or whatever, out for years, decades, and then protect it. Then go and file for protection. Same with your trademark.
Like my coaching program, I had 5 years before I did mine.
Yeah, because you get common law protection, and it actually gets stronger during that period. But with patents, when you disclose your idea, or you sell it, or you offer it for sale, that starts a 1-year clock ticking. And at the end of that year, you bar yourself from getting a patent on your own technology.
Oh my gosh.
So never. You're just done.
Yeah, at least on that version. We have had cases where clients have come in and they haven't known that. And we say, well, 1.0 is gone, but what about 2.0?
Okay, so there's some ways around
You're still
that.
inventing, right?
Yes.
They go, oh yeah, we're still inventing.
Yeah.
So we can come in, and if the changes that they're making are significant enough that they're patentable on their own, then we can come in and help later on. But it's much better in the beginning, and that's why we always try and encourage people, even if you don't know if you have something that's patentable, come to me or other reputable patent attorney will usually, give you a free consultation and say, hey, do I have something here that I need to worry about that I should try and protect? So let's say you just have this new idea or this new concept or invention. The first thing that people usually want to do is talk about it. They want to tell an advisor, or they want to tell a potential investor. So how can they protect themselves? So the two main ways people can do that is either by using a non-disclosure agreement, or by using what's called a provisional patent. Both of them have limitations, but they both are far better than nothing. The problems with non-disclosure agreements is that a lot of investors and venture capital people just won't sign them. There can also be some issues as to, what's your recourse if someone violates it. You only have a contract recourse, you don't have patent recourse. And then with a provisional application, that gives you a 1-year placeholder during which to go back and file a real patent on that. So you can file those usually pretty quickly and, at a fraction of the cost of an actual patent. And then you can have some protection to go and talk to whoever you want to talk about and know that you're not going to be shooting yourself in the foot. There's some dangers there, though, is you're only protecting what you actually file on. So if you file a real short provisional and then go and talk beyond what's covered in there, everything beyond what was covered is
fair game
for you to be shooting yourself in the foot again.
Oh, bummer.
Wow. Well, Brooke, thank you so much. I wish we had more time with you. You have so much information around this, and I just really appreciate you coming in and sharing with our listeners.
It was a pleasure to be here. Thanks
We'll
for
have
having
to have
me.
you back.
Sounds good.
And coming up next in the Money Hour, the current market shift in pricing your home accordingly. We have Darren Dahan and Carly Willis of DCD Property Group right here at 1150 AM KKNW after this short break.